Madam Mayor, we are ready.
Okay.
We're streaming already, so.
So I'll go ahead and call this City Council work session to order. It's appeals versus litigation and council involvement. Training by our City Attorney Brooks Chandler. We're getting additional council members on the line, and also Brooks, because he's being COVID conscious. And
Welcome to the GCI Conference Center. Please enter your access code.
2.5 hours.
Thank you. Please stand by. If you are the chairperson, please enter. You will now be placed into conference. There are 4 participants in the conference.
hi there, you are on with the Seward City Council work session. I'm gonna go ahead and I'll just call out and see who's on. Brooks, do we have you on the line? Okay, I'll check for John. John, do we have you on the line?
Yeah, I'm here.
Thank you. Liz, are you on the line?
Yep, I'm here.
Great, thank you. Rissy, are you on the line?
Here.
Great, and so I'll just check one more time for Brooks. Okay, we'll give him a few minutes. I think the city clerk is sending him a text. So if you guys are watching YouTube, you can see that we're going to have the presentation also up on the screen. And just for folks on the phone, we have, I should have used your last name, sorry about that, folks on the phone, but we have Councilmember Cease, we have Vice Mayor Baclan, we have myself yelling into the microphone as usual, and then we have Councilmember McClure. The city clerk is here, acting city manager, and assistant city manager.
I'm not sure that, I'm just texting him again, the
Yep.
access code
Oh, okay.
and phone number.
Brooks? I'm guessing that's Brooks connecting.
Good evening.
Good evening, welcome. Thank you. We're going to start off with you leading the presentation, sir, so whenever you're ready.
Okay, great. It's going to be a little bit different. Some of you will be, I think, following along from home, referencing a packet of materials that consist of slides of a PowerPoint presentation. Some of you will be watching the slides on the TV. The packet that I received did have to rotate, I think, a little bit so that you're not standing on your head to look at the slides. I'm going to be talking about 2 general areas, if time permits, and I can take questions sort of at any time, but I guess there may need to be a process at your end to organize questions, and so maybe most of them will come at the end.
Yeah, that'd be great. Let's just have you go through your presentation unless someone really has a burning question, if they could jot it down, and then we'll circle back to questions at the end. And then we do have a member of the public that will be calling also.
Okay, great. So I'm going to be talking about 2 areas that I think are especially challenging for elected officials. One has to do with sitting as an appeal board, and the other one has to do with appeals to the Seward City Council. And I know most of the people I'm talking to have been on the council for a while, so you've probably experienced having to decide an appeal. You can go on to the next slide. This illustrates, I think, how you have to differentiate between the two functions that you serve as an elected official for the people of Seward. And I think the one that people are most familiar with and the one that inspires most people to serve on city councils is the legislative function. And frankly, these images, they aren't supposed to be perfect analogies or anything, but I think they do demonstrate what the big difference is between the two roles. As a legislator, council is free to do all sorts of things in the process of making a decision through the fundamental lens of, what do I think is in the best interest of the people that live in Seward. You can run around and do your own investigation on an issue. You can look up medical journals. You can research history. You can talk to anyone you want to. You can take all kinds of input. There's no real limit to how you go about making a decision when you're acting as a legislative body. So in that respect, I think the image of Jack Sparrow is probably more appropriate, not that folks act like pirates when they're legislators, but the fact that you have a lot more freedom to act, and whereas the more prim and proper woman that's on this slide is more like the constraints you might have when you act as an appeal body, because there are a lot more rules and limits on what you, as a decision maker, can do in the process of making a decision on a particular appeal. And I think, if any of you like to watch the Pirates of the Caribbean, one of my favorite scenes is when they're in Barbarossa's ship, and Sparrow is in confinement, and they decide they have to consult the code, and they bring out this massive book, blow the dust off it, look up all this stuff, and then decide, Barbarossa says, well, really this is just more of a guideline than a code. In some respects, that's more like what you do when you make decisions as a legislative body. And in fact, and you don't even necessarily have to be consistent, right? One year you can decide to do one thing, one year you can decide to do another. We saw that recently with the Supreme Court nomination, right? Where people, 2 years or 3 years ago, they said one thing, and then this year did something else. So, and I want to focus, on what are some of these constraints when you sit as an appeal body. So you can go to the next slide. I kind of covered this, and so we can just move on to the next one. The next few slides are just going to show examples taken from the Seward City Code of what are the situations where the council might sit as an appeal body. So if you go to the next slide, interestingly, this one from Title 14 has to do with hooking up into the electric grid. And so I bet that doesn't come up hardly at all. The Title 3 one is specific to personnel grievances that might come out of the city clerk's office. It's not, I don't know if you've had any experience on those, and frankly, from looking at the code, I'm not entirely sure what happens after this confidential information memo goes to the council, but it could be that it ends up being some sort of an appeal type process. If you go to the next slide, this Title 15, I think, is one that's probably the most likely to come before council. This is the planning and zoning code. And so the familiar ones here would be variances or conditional use permits, perhaps. The Title 12 one is building code rules and regulations. Theoretically, that could end up in an appeal before the council. And then if you flip over to the next slide, there's a couple other code provisions here, business licenses, and the one from Title 9 has to do with abating dangerous buildings. And I was kind of amused when I saw, there's all these very specific references to these books and uniform things. I said, oh yeah, we're back with Captain Barbarossa, because down at the end, well, whatever procedure the council thinks is okay. So that one could become interesting if there's an appeal under this provision of your code. This will definitely be a very tiny amount of the service you provide to the citizens of Seward while you're in office. People have been, elected because your judgment on a lot of things is trusted in making day-to-day decisions on behalf of the citizens. And for the most part, those judgments won't involve appeal. And that's why I think this training is worthwhile, because it's very easy to think that sitting on an appeal is the same as anything else that you do as a city council member, and it really isn't. There are special legal rules that apply, and it's good to know a little bit about them ahead of time, and not be surprised to find out as appeals come up. So if you go to the next slide, flip the page in your packet, these are the things I'm going to talk about in a little bit more detail here. And we're going to, the only one from this list that directly applies when council acts as a legislative body, the one at the bottom, conflict of interest, that does apply across the board. And to a lesser extent, the idea of due process of law can also apply to the legislative body. If you now go to the next slide, due process is kind of a catchphrase, a legal catchphrase, but it really extends all the way back to the initial drafting of the Constitution in the 1780s by all these guys with wigs and silk stockings. Go to the next page. The same concept is in the Alaska Constitution. 200 plus years later, and there actually are some women in this. If you squint, you'll see beautiful women in these pictures, and the silk stockings have been replaced by white shirts as part of the uniform. But these are fundamental concepts. If you go to the next slide, here's how it appears in words. One of the concepts in our country embodied in the Constitution is that people will be treated equally, both in terms of what their rights are and in the opportunities they have to talk to people like you about their particular situation. And if you go to the next slide, again, from the federal Constitution via amendments right after the Civil War, the significance of this is that it extended the concept in the federal Constitution to each state in the United States. But in Alaska, this is not really relevant because our state constitution is worded pretty much the same as the federal Constitution. So what are these kind of lofty concepts, due actually happens in council chambers during appeals. If you go to the next slide now, I'll go over a few of the concepts there. And again, these are the council sitting and making decisions as an appeal body. Typically, those are going to involve very specific people and a very specific situation. And the idea that there would be consistency in decision making so that people that are in similar situations are treated in similar fashion is embodied in this concept of the slide that we just saw about equal protection, that people are generally treated the same in legal appeal situations. And decisions are supposed to have some logic to them. In fact, quite a bit more logic than perhaps a decision that you would make as a legislative body. And you can't do one thing in one case and then maybe do something 180 degrees differently in another case. And just again, to give the Supreme Court appointment at the federal level as an example, if 4 years ago that had been a court case with a court decision that said, no Supreme Court justice shall be confirmed during the last 5 months of a presidential administration, as a court decision, that well may have been binding on the United States Senate this year, but it was not a court decision, it was a legislative decision. So they were completely free to do something different. Not necessarily the case when you're sitting as deciding an appeal as a council member. We go to the next slide, and again, these are basic concepts tied up in treating people equally and acting consistently. And it's part of what is a fundamental difference between acting as a legislature and acting as a judge in an appeal case. When you're a judge in an appeal case, you can't run out and solicit information from the other citizens in Seward that might not be directly involved in the appeal. In fact, you're not even supposed to call up the person that is going to be appearing before you and head something that they are appealing. You're supposed to be being presented with a packet of information which is similar to the packet that you get every council meeting, but unlike most council meetings, you're not supposed to stray outside the packet, like on the zoning matter. It's not up to you as an individual council member to run out and say, well, I'm going to look at this property for myself and take some pictures and show them to the other people in the council and use that as a basis to make a decision. It's supposed to be based on what's called facts in the record. And that record usually is prepared by the person whose decision is being appealed from. So it might be the Planning and Zoning Commission or the planning staff that's put together the record of, this is what we did and this is why we did it. It might be the building official if it's a building code matter. It might be the city manager if it's a business license matter. But you are sort of confined in what you do when you are deciding appeals in a way that you're not confined when you act on other matters. Another way that you're confined is most appeals are specific to certain provisions that are in the city code that establish what the standards are and when an appeal could be granted or not granted. And next, if we go to the next slide, I believe it's an example. Yes, here we are in, this is actually a section of code that sets the standards for building code, fire code type appeals, where somebody has asked or either been cited because they're building something that's not the code, and they go, I don't agree, and I want to have an appeal. And so, as somebody that's being asked to decide the appeal, you as a city council member will need to refer to specific things that are already in the code, as opposed to making sort of an independent judgment of, well, what do I think is in the best interest of the people of Seward, which is the kind of thing we do at every single meeting. That's not how you do it with appeals. You actually look at, okay, I have to decide very specific things and think about very specific things. There's 4 particular standards here. Other parts of your code will have other standards. We're not necessarily going to go through them in any great detail here because it's a general training session. But if you look at the next slide, you find it right away. They're in there. You've got very specific things that people have to prove and what are they entitled to a variance, whether it's from floodplain or other planning and zoning regulations. And you can't say, well, I don't care what the code says, I'm just going to do what I think is best. That's not how it works when the council sits as an appeal body. And we can go to the next slide and page, and I'll talk about procedure a little bit, because there are procedural restraints also. I already mentioned this idea that you decide appeals based on what is in the record that's prepared and put in front of you. And I have found over the years that this first item about no new evidence being received when an appeal is before a city council, oftentimes is a challenge. It's a challenge for everyone because a lot of times appeals involve citizens that are, this is not what they do on a day-to-day basis. They will not have had reason to be appealing anything to city council maybe ever before. And there's a tendency to think that, well, until I actually get in front of the city council, I don't really have to have all my ducks in a row, so to speak. So you may frequently encounter a situation where somebody is coming before you with an appeal and wanting to provide all these new photos or all this new information that they did not give to the person that made the initial decision. And this, at least in the planning and zoning context, which is the 1510-415, is, a no-go type area. It says right in the code, we're not going to take new evidence. And if that's what you think you need to do, we're going to have to start over the whole process. It's going to have to go down one level before it gets to us as an appeal body. Here's the second item that is very different from a lot of things councils decide, is there may be no testimony by the general public in the context of an appeal. When you get before the council and have the section of the meeting where you're considering an appeal, it's not necessarily, you don't necessarily look out there and go, hey, does anyone want to comment on this? That isn't necessarily an ironclad rule. Sometimes code provisions will say, well, an appeal is going to be a public hearing, and therefore the idea is that people could come and make statements, but that's an exception. The standard process does not involve general public testimony. It just involves the people that are directly making the appeal talking to you, as well as the person that made the decision that the appeal originates from that will be talking to you. The city attorney's role in appeals, there are two different aspects to it. I've certainly served in both functions. One is sometimes the attorney can actually be presenting the argument about why an appeal should or should not be granted, because they've been asked to do that by the official or the body, in the case of the Planning and Zoning Commission, that made the original decision. Other times, the officials involved present the case themselves without help from the city attorney, and the city attorney in situations like that, the only involvement may be as an advisor to you as the city council, as members of the Board of Appeals, which means the city attorney won't be advocating for any particular outcome on the appeal, but will be advising you on, what is the procedure, what are the appropriate things to consider, maybe what do the standards say in the code, and maybe helping write a written decision. And if we go to the next slide, I just mentioned written decisions. Unlike votes on ordinances or things, they don't have to actually have a written decision. Most of the reasons the council gives when they act as a legislative body are done out loud in public during public meetings. But here with appeals, the written decision is many times it's actually required, and it is in your code when it comes to planning and zoning appeals. It's not necessarily required for every single variety of appeal that the council might be involved with, but it's certainly highly recommended no matter what the appeal is. And the reason you have a written decision is that the city council isn't necessarily the last stop in the process that we have in our country for appeals of this nature. Virtually every decision the city council makes on an appeal can be appealed again to a court, to a judge. And judges in Alaska have said over the years that we can't take on appeals and decide what the outcome is if we are not able to understand the reasons why the city council granted the appeal or did not grant the appeal. And although we're willing to try to figure that out from what people said, it's definitely better if it's all done in writing. And that's also better, in my opinion, for the public as well, to know why the council decided an appeal in a particular way, and that includes both the people directly involved in the appeal as well as other citizens of Seward. If we go to the next slide, I've experienced all of these items in the context of appeals that are decided by the city council. And these are things that just to be aware of when written decisions are being prepared is there should be an explanation for every aspect of the decision. And this is especially true if the council is disagreeing with a staff recommendation or an official recommendation, because those are often in writing, and it's certainly does not mean that the council always has to go along with whatever other parts of the city have decided on something. In fact, it's, these decisions are not binding on the council, or there may be a burden of proof of the person involved in an appeal that has to overcome, but that can be done. I've seen it done. And when the city council is disagreeing with a department or administrative official recommendation, it's very important to explain why in the written findings. And then finally, again, just a reminder that appeals there's a limited universe of information and facts that should form the basis of a decision, even when the decision is in writing. And those should be items that are actually in the record that is before the council. I'm going to skip over this slide because it really should have been earlier in the organization of this presentation. But I will comment briefly on what due process of law actually means. And it really means that people have a reasonable opportunity to be heard before the government takes action that impacts their private property. And that's one of the whole reasons that we have these provisions in the city code that allow for appeals to the city council. Is the appeal itself is part of the concept of due process. This is, if you go to the next slide, part of the components of due process are these things that I mentioned just a few minutes ago, really. You're following standards, there's some consistency, and there is some logic to what is done. And now to get into some of the more detailed components of concepts that are embodied in this idea of due process in our country, and what it means when elected officials are deciding appeals. And here's sort of the three that come up more frequently than not in the context of appeals. One I think will be quite familiar to you is that there would not be a conflict of interest. So in that regard, the same sort of rules apply as when you sit as a legislative body, and it involves around financial interests primarily. If you have some kind of financial connection to the matter that's being appealed, obviously you should not be sitting as a judge. Bias is something that is quite a bit different than conflict of interest, and it's quite a bit broader, and it's fairly significant component of the concept of due process. Everyone understands that when you go before a judge or a jury, you expect that person or that body to come in to a process having not already made up their minds or not being inclined to favor one side or the other. And bias can involve things other than money. And especially in a smaller community, I think it's important that council members do a self-check and ask themselves, am I going to be able to be an impartial and neutral decision maker in the proceeding that's before me? Can I do that? Am I going to be influenced by the fact that I know the people involved in the appeal? Am I going to be influenced by the fact that, I have, that the appeal involves something that I've previously talked about. And these types of things in smaller communities can come up more frequently. And it's not, oh, I know somebody, therefore I can't possibly decide it. That's not how it works. It's almost expected that in a community the size of Seward, people that are on the city council might very well know people that are involved in the appeal. It's not, do I know this person? Is my relationship with them so much a part of me that I just am not able to come into this thing as a unbiased, impartial decider. I don't want to damage my personal. I'm afraid that I can't separate my personal relationship with the people that are involved from the sort of issues and the substance that I'm being asked to decide. That is something that I think people should ask themselves every single time that there's an appeal before them. Ex parte communication is another concept that's it's a little bit, it's a challenge for people that have been willing to serve on the city council, because part of what is part of your duty and your job is to take input from the citizens of Seward on the issues that come before you. But when you're sitting on as an appeal body, it's exactly the opposite. It's exactly the opposite of what you're so used to doing, and making yourself available for people to contact. You're not supposed to talk to anybody about a matter that's being appealed until such time as you actually get into the council chambers and the people involved in the appeal are before you. Now, why is that? Does that actually make sense? Here's why. Here's the idea. This is the concept behind this rule of no ex parte communication. One concept is the people involved in an appeal should know exactly every bit of input that's coming to the person that's deciding the appeal. So, and why should they know that? They should know that so that they have an opportunity to rebut it, or to say, what you just heard isn't correct, or there's something that's not quite right about it. And that is part of the larger concept of due process and fundamental fairness. The other aspect of this has to do with the idea of judicial review, which also is sort of evaluated based on what's called the record that's before the city council. And with ex parte communication, that's not necessarily, doesn't always show up in a record. I mean, it wouldn't if you allowed it. It wouldn't necessarily show up in the record. If people could just call up folks that were sitting as judges and say, "Hey, here's my 2 cents on how you ought to decide this matter," and that also is considered to be contrary to the idea of what is fundamentally fair. So, and this takes, people have to be conscious that this is not supposed to happen. A lot of times it does happen, and there are ways to address it. And the way that ex parte communication is addressed is, if it has happened, it's disclosed on the record at the very beginning of an appeal process. That way, everyone involved knows what the ex parte communication was. Therefore, they do have an opportunity to argue that whatever was told, was being said, was incorrect. Or 2, it becomes sort of part of the record when it's revealed at the beginning of a proceeding. and people can then evaluate whether that had some sort of inappropriate influence on the decision. But just because there's ways to deal with it doesn't mean that, you still should avoid it. Very, very rigorously avoid it. It makes things more complicated than they need to be, and it's really inconsistent with the concept of due process. You can go to the next slide now. This is simply the code provision on conflict of interest, which I've talked about. The Seward Code does not necessarily define in dollar terms what a substantial financial interest is, so that can be a little bit of a fuzzy area. And there's been a couple of Alaska Supreme Court cases in a context that might apply to you as an appeal body. It's a planning and zoning context. And so we'll go to the next slide. Both of these cases came out of the city of Homer and involved a Homer citizen named Frank Griswold. And they actually provide sort of the boundaries when in a planning and zoning context of this concept of, hey, what is a substantial financial interest? And it's tied up in property ownership. And because of these two cases, it's a little bit easier to draw the line. And it's whether a decision would likely and fairly soon impact the value of property that's owned by the person making the decision or participating in the decision, one of the decision makers of a body. And then, but if it is more speculative and a lot of other things have to happen in the future that might or might not happen before a decision would impact property value, then that is not a substantial financial interest. So it's a little bit better than nothing. It won't necessarily give an easy answer in every case, but this is how this concept of what is a substantial financial interest in the context of a planning and zoning matter has played out in the Alaska Supreme Court.
Hey Brooks, before I'll stop you here before you start talking about bias. We have one person we need to call for comments, and then I'll see if there's council questions, and then we'll have you keep going until about 5 minutes to 7, okay?
Yes, I
Okay.
get a feeling I'm not going to make it to part 2 of this presentation.
Well, you're doing good. I know there's lots of meat on that bone, but let's make sure we reach out to the public. So,
Sure.
Brenda, would you make
Okay.
that first phone call, please?
We're calling Milan Paquette.
Hello,
Hi, this is Malan?
this is.
You are with City Council in the work session for, with the city attorney, and you can make your comments.
Hi. Yes, thank you for calling me for this opportunity to provide a brief public testimony. I have been reviewing a couple City of Seward forms and public procedure documents by the police department. And I don't know if any of you have reviewed your website recently, but it's very interesting. I did a quick review since speaking to the clerk this morning. It looks like Seward is one of 2 departments that in the borough that are offering a employee conduct form for the police department. So 2 out of 4 is pretty good. We're one of those 2, or you're one of those 2. So the form has a 3-page download, cover page with instructions, and the procedure, SPD Regulations and Operations Manual, the Chapter 4 is public document as well. And so I'll be speaking on that, and then the comparison document you have, request for public record, City of Seward clerks put their contact information. No email, but still a fluid process. City of Seward Police Department Employee Conduct Form, once printed, has no way to contact them. No phone number, no fax number, no email, no website. No lieutenant for the department's internal affairs officer contact information. So, first paragraph has a couple typos, but nonetheless, if you have that cover page in front of you, please reflect on alternative procedures
So,
where
so I'm gonna go ahead and
Hold on.
I'm gonna interrupt you for just a second. So we're in a work session.
speaking.
This
Yeah.
is the Mayor Christy Terry. So
About, I had an idea for you for the improved presentation of the City of Seward to the public.
okay, so we're in.
The alternative procedures, your police department lists several dead ends.
Yeah. So ma'am,
Advisable alternative procedures
ma'am,
include the Alaska Police Standard Council and
Ma'am?
Police with Crime Stoppers.
ma'am, I'm
Other
happy to hear your comments. I just want you to take 1 second and listen to me,
police
please.
departments in the borough.
Ma'am, would you just wait? Well, I'm happy to take your
Crime
comments.
Stoppers would be helpful for improved presentation and reduced image of conflict of interest, reduced liability
Yes,
for
ma'am.
conflict of interest.
We're in a work session about appeals versus
Now,
legislation.
quiz. Who is City of Seward HR Supervisor of Personnel? Married to?
Ma'am,
Option A,
we're gonna.
Lieutenant
I'll be happy to call you tomorrow or get someone to call you offline.
with the SEC.
Right now, we're in a work session about appeals. So I'm gonna let you go ahead and,
Grateful.
Malon.
yeah, we'll give, can you,
We'll follow up with you at another time, Malon. Thank you.
so I'm gonna reach out to council. We're running out of time, but I wanna make sure and see if there's any questions. I'll start with the folks online first. Councilmember Osinga, did you have any questions for the city attorney based on the presentation thus far, or any questions regarding this topic?
I have no questions.
Thank you. Councilmember Demas?
I do not, thank you.
Thank you. Councilmember Casagrande?
No.
Thank you. I'll look around the dais real quick. Administration? Okay, Brooks, you know what? We're gonna take advantage of you and have you go for another 5 minutes if you're willing to keep going.
Yes, let's do it.
Thank you.
I think I may have covered many of the topics on these last slides, but let's never hurt to be a little bit repetitive. So here's one on bias. And the one I didn't talk about is down at the bottom, the last bullet point here, is the fact that bias could be raised by one of the participants in an appeal. They could at the beginning say, I think Councilmember X should not sit on this appeal because, their daughter is going out with my son or, whatever it might be. It actually could be raised by a party. I do recommend that people self-examine it as a decision maker. Just by way of example, I had a recent case where the judge, made a disclosure that, hey, my kids are on the same soccer team as the kids of this other attorney in the case. It doesn't affect me. I can still make an unbiased decision, but I felt like I should let people know in case you want to object to me continuing to be a judge of that. If bias is raised by a party, if they do say, I don't think this person should sit because they're biased, that is examined and it's going to be decided by the council as a whole whether or not they think that that is a disqualification or not. And in the process of doing that, usually it's a very standard question. Just ask the particular council member, hey, do you think you can be a neutral, impartial decision maker? If you go to the next slide, here are some of the indicators that bias could be an issue, and it certainly, as I said before, can be more likely to come up in a smaller community. And the one that I think is, unusual, but I have seen it come up, is this previous public comment. So let me give as an example. We just went through an exercise of amending the code having to do with communication towers, cell phone towers. And so that was a legislative act. It's theoretically possible that in the course of commenting on the ordinance in 2020, somebody on the council said, I really don't think cell phone towers should be in this part of town ever, ever. They shouldn't be there. And that comment is perfectly appropriate for someone to make when they're deciding on an ordinance. But maybe 2 years later, here comes an applicant to construct a cell phone tower whose permit has not been granted, and they've appealed to the planning commission and then on to the city council, and this same person who made this statement when the ordinance was adopted is now going to judge whether or not they should have a permit. That's an example of how a previous public comment might lead to a conclusion that, hey, that person is biased. There's some other kinds of things we'll go through. These are fairly common sense, and I'll just go through fairly quickly, but obviously, review the information before you make a decision. You can go to the next slide. This is a nice example of somebody of what bias is, right? Come in with your own opinion on what should happen without having actually, opened the packet and looked at it, just because of what the decision is that's involved. Here's one that I think is somewhat tricky because one of the aspects of volunteering for public service as a member of the city council is, you have to organize your time, and you're given a packet of information with regard to an appeal, usually a few days before the meeting's actually taking place, and it makes sense to review it. I mean, it makes sense to look at it before you come in and hear from the participants in the appeal, just so that you're more prepared, because you might be asked to make a decision, 10 minutes after the presentation's done. And it's just the nature of an administrative type appeal that the people participating in the appeal would also expect you to have, read some of the material before you come into the meeting. But in the process of doing that, I advise people that it's important not to decide, you read it, to review it, so you're familiar with it, but don't decide in advance before you've even opened up the meeting. be listening to what people are telling you during the actual appeal process.
Hey Brooks, and on that good note, I'm gonna wrap up this work session and just say if, you know, these other slides are quite eye-catching and quite good. I'll just ask council to review the last slides, and if they have any questions, let's send them to the city clerk, and she can gather questions and send them out to you. And I think if a council member has questions, then I'm sure other council members have questions, and we'll just send them to you and maybe get them back to the body. But we'll give everyone a chance to just take a bathroom break before the meeting. But good stuff today, we appreciate it.
Thank you very much. I like having these opportunities. I'm glad you gave it to me. And I'll be talking to you a little bit later in the meeting itself. So.
Great, we'll get back to you, thank you. And with that, I'll adjourn the work session.